Alright, episode for movie be akwaba family two kidneys and blossom e YouTube so asi episode aba ensem ahodo a ekoso no ene de besuma hefo nyina me no kase na ensem ahodo info bi adrop episode nya asem keto akra na ode ne pen yi na we efa Chairman Wontumi episode be koni akwa akwa jinsem nyina enchiru mese osansa na ubu ene ani di kwa se munya subscribe from my YouTube channel ya na do nsa abo subscribe button so we na the bell notification icon so to was le next time ya no we drop video our channel one se be kevin bi and so never detail na say encha ekra na chese beto dwa anase nyani hu eye video bi na e circulate e wo internet ne so ani nyina fa Chairman Wontumi ho say eye EOCO for ache no san so ani beto dwa say eye Akonta Min no honsensem ne se bebre na bisu ache say na Ghana for na say painful e bono eye kwadu e wo ho na me ka say no detail nya say eji atoni general san ba bon tela be ka say Chairman Wontumi eja EOCO fuja na yenya na sa akwa enche obesa so akwa ku pil e wo court na akwa ku yi na ho ensem bi ano ebien kwai nkutie eji emfambra medin elkwam gentle.
The All Africa Games and the drip scandals are being prepared by the National Investigation Bureau for my attention. I expect to receive that investigative report in a few weeks for work to begin on filing charges in court. The Economic and Organized Crime Office has completed investigations in respect of Wontumi, Chairman Wontumi, and the former National Buffer Stock Company CEO, Mr. Abdul Wahab Hanan, and their accomplices. The results of both investigations will be announced very soon. The police CID have also completed a docket on the Akonta mining case and submitted same to my office. We have prepared charges and sent them back to the police CID for the suspects to be formally charged before their arraignment in court in the coming days. Ladies and gentlemen of the media, my fellow countrymen and women, in conclusion, I wish to remind you of the fact that when I announced the Kobina Idubohin investigation, I was blunt in stating the fact that I am open to engaging in plea bargaining with those who have been investigated and found to have looted or stolen state resources. I minced no words about my intentions and will therefore not shut the door to any accused person willing to enter into negotiations with my office for purposes of reaching a plea agreement. My approach is in consonance with the central plank of the oral, which is to recover the loot, which is to recover all the loot. But of course, you use all advisedly, because as I pointed out clearly, it is not in all cases that it is possible to recover all the loot. So you recover some, realistically possible. Of course, recovering the loot and jailing looters are not mutually exclusive. And I believe that that is what citizens are pushing for. In other words, both can take place and that will be full-fledged accountability. But anyone familiar with the plea negotiations would agree that it is rare to go into the negotiation room and come out without giving up something in order to clinch a deal. Our plea bargain statute captures that succinctly, as it contemplates that the Attorney General may even go to the extent of dropping charges in exchange for restitution. Also, under the Costs Act 1993, Act 459, an accused may plead guilty to a charge or charges and pay restitution where the offense involves harm to the property of the Republic, including financial resources. In that case, the accused is to be handed a non-custodial sentence. As the Attorney General, I will not oppose the use of Section 35 of the Costs Act to achieve the purposes of oral. Now, Section 35 is mandatory. Once the accused approaches the judge, and pleads guilty to the charge, the judge is mandated, the judge could reject the restitution or reject the offer of the accused person. But once the judge accepts the offer of the accused person, I have no role in it, all right? Then the accused person must be given a non-custodial sentence. In other words, the accused person will walk home. So those who are saying that you are cutting a deal and letting criminals walk must understand that, even the legislative framework existing at the time that I was in law school, I was in final year in Legon when this act was enacted, contemplates that in some cases, the accused can pay restitution and get a non-custodial sentence. So if any accused person offers to come under Section 35, please ladies and gentlemen, that is what Parliament has enacted. The Parliament of the first Parliament of the Fourth Republic. Do not expect that I will be able to say, do not impose. If once the judge accepts it, okay, I can make my representation to the judge as to why this is not a fit and proper case for restitution and a non-custodial sentence. Okay, but that can be rejected because the statute imposes, right, the power and authority to determine the circumstances under which that will happen in the judge, not in the Attorney General. The Plea Bargain Act, on the other hand, okay, imposes the power and authority to, negotiate the deal in the Attorney General. However, the judge has a role to play. The plea agreement must be endorsed by the judge before, it is accepted. Finally, make no mistake, ladies and gentlemen, about my intentions. I want to jail persons who have looted state resources, but at the same time, I am pragmatic enough to know that it is not in every instance that is possible. In those circumstances, I will opt for non-conviction-based asset recovery. I thank you very much. Now, with respect to Abdul Kumanov, the arrests have been effected, and you know that when arrests have been effected, you don't go straight, to court. You need to conduct an investigation, prepare a docket, and then you proceed to charge. So that is taking place, and we are taking a very serious view of all electoral, violence. Okay, violence arising out of or in connection with all elections in this country. So for us, it's very comprehensive, and the president has, made it very, very clear that it doesn't matter which side of the political divide you belong to. We will investigate and prosecute, all of them. Now, when it comes to the illegal mining, prosecutions are taking place. Okay, we are prosecuting. In fact, we have decided that we are setting up more special courts. Okay, under the New Patriotic Party government, the former Chief Justice Eni Yeboah, designated certain courts as special courts for illegal mining prosecutions. Okay, so we are going to expand those ones. And then also, when the tribunals bill, the public tribunals bill is ready, I have submitted it to Parliament. We'll be sending a lot of them to the public tribunals at the district level for prosecution all over the country. In respect of deported Chinese, as the Honorable Minister has pointed out, I don't have the statistics. Okay, these are better gotten from the Minister of Interior. Now, on legal education, the question was a bit lengthy, but what I picked up are two things. Bridging the gap between the private law schools and the public law schools. Now, I don't know what you meant by bridging the gap. If you are talking about government support, someone who establishes their private, university, has the obligation to find resources for that university to, operate, in terms of, being able to run all its programs and so on. So it is not a duty. If government wants to subsidize them, that is a different matter. That's a privilege, not a right. So I don't think that government will be pouring. In fact, we are having difficulties funding all the existing public universities. And to add the private universities to our load is not, I think, a very prudent thing to do. The second thing that I picked up was with respect to the promise to reset legal education. And that is very, very important. And that promise is that we are going to reform legal education in such a way that access will be expanded. Okay, so that currently we have thousands of LLB holders who cannot get to, to become lawyers because they cannot enter the Ghana School of Law. All right. We want the bill that I have drafted and which is will be submitted to cabinet next month, is to the effect that we are going to literally abolish the Ghana School of Law system. All right. basically what we are going to do is that you will have 3 years of legal education to obtain your degree, that is the LLB. After obtaining the degree, the LLB degree, you now do what we call either the clinical legal, program or the bar practice course in the university where you got your LLB for another academic year. And then you write what we term the National Bar Exam. Okay, so everybody who has the LLB and who has taken the bar practice course in their school, in their university, all right, will be entitled to write the National Bar Exam. So it will be like what the accountants do, all right? Once you qualify to write the examination, the Chartered Institute of Accountants will administer the exam, and everybody, can write. And if you pass, you become a chartered accountant. That is what is going to happen in order to expand legal education in the country. So the bill, as I speak, in fact, is interesting that you asked, because I forwarded the final draft to my able deputy, an academic, Justice Rimsai, to review and then give me his input before we submit it to cabinet. That was just only yesterday that I sent it to him. Then there is a question of the assigning of the properties. Okay, that was something that the shareholders, kept saying. You see, the whole case centered around these related parties, activities, okay, transactions, okay, where Holder Holdings, Uni Securities, of course, in the press release, you remember the 0.3, billion, which was given to, which was given to Uni Securities, which is a SEC-regulated entity, which is being pursued. Okay, so the whole idea, that is why the misconception being spread by certain elements, certain citizens, to the effect that Dufour and his family were basically looting, resources from the bank, is misplaced. Okay, these were all related entity transactions. Okay, and I will encourage all of you, you should probably read the Beige Capital Court of Appeal decision, because the scenarios are the same. All right, so they were insisting that, look, if these are properties held by related parties, simply just transfer them to Unibank, and then you will have you have recovered enough to be able to satisfy the liability. But that was something that was in dispute in the case. Okay, now with this settlement, it brings all those matters to rest. Secondly, you asked about the ECG. Prosecute. Yes, but that's what I'm coming to. Yes, so the missing containers investigation, I was given a preliminary report on it. Okay, I reviewed the report and I sent it back to the Director General CID to do further investigations. I directed them, and that is what we do in the office. When we read an investigative report and we see gaps, because all that a defense lawyer needs to do is to raise reasonable doubt, okay, and then the case will be thrown out. In order that we prevent a situation where reasonable doubt is being raised, we seal the gaps before we charge the people, and we have sent it back for them to be to do further investigation.